All right, good afternoon. My name is Detective Sergeant Patrick Beimler. I'm with the Glendale Police Department. I'm the Family Violence Unit Supervisor in the Criminal Investigations Division. And with me is Hillary Weinberg with the Maricopa County Attorney's Office.
All right, good lunchtime, everybody. Thank you for joining us today. I'm glad that you're here to listen to our presentation on domestic violence issues. Domestic violence, as far as my perspective is, it's basically almost a homicide waiting to happen. This is one of the most lethal things that we handle in our office. It's very important to us. I'm going to go ahead and let Sergeant Beimler go ahead and start the presentation, and then at the certain point I'll take over my portion of it, and we hope to have a little bit of time at the end for some questions. All right, thank you.
All right, so before we get started, just let everybody know this is being filmed and recorded, so I'm kind of stuck firmly planted behind the microphone here. Otherwise, I'd kind of normally be out and talking and answering questions with you guys. We're going to try and, this normally would be probably a 3 to 4 hour training, and we're trying to cram it into this lunch hour with time for questions too. So I'm going to be going through a lot of these aspects fairly quickly. So again, if you've got questions, remember them for the end, and we'll try and go through and touch base on all those things. And we'll be available after the presentation as well if there's anything in more detail that you want to have answered. But we want to try and get through as much of the material as we can in the time we have allotted. Many of these best practices are derived from the MAG felony protocol model. So what you see here is a lot of the different aspects. If you're familiar with the protocol model, you'll see a lot of similar things. But what we're also going to look at is some aspects that we at the Glendale Police Department have incorporated into our domestic violence protocol, such as lethality and coercive control assessment, some of the training we do on strangulation, and so forth. So you can kind of take and glean from what we have and kind of use it for your own, as well as the protocol model itself. So starting with the 911 call, you're going to have the dispatch and the initial response to that domestic violence call. We want to try and always get 2 officers or deputies, if possible, to respond. Obviously, domestic violence calls are very dynamic, very emotionally driven, and a lot of times the immediate need for a backup is going to be present. So there's always going to be some a desire to want to have at least 2 officers respond on all DVs when that's available. The dispatcher is going to want to brief the responding officers on the details of the call. Obviously, whatever the call taker information is needs to be relayed in an orderly fashion, in a timely fashion to those responding officers so that they have all the information going into the call and aren't blindsided by anything that we should have known prior to responding. You're always going to be alert for weapons. And again, even if weapons aren't part of the initial call for service, just be alert that weapons might be on scene. Anytime you go to a residence, there's always going to be weapons, kitchen knives, those types of things, not necessarily firearms, but just be aware of the surroundings so that you're not taken off guard by anything that could be used as a weapon. Just like any normal call for service, you don't want to park directly in front of the residence. There have been officers that have been ambushed on their way to a domestic violence call when the suspect knows that police have been called and are responding. So we don't want to park directly in front. We want to park a few houses down, make a safe approach when you're responding to those calls. We're going to begin recording of our digital recorder, or some agencies have the body-worn cameras. You want to make sure that those are active from the moment you get out of your vehicle and make your approach. There's been a kind of a change in the way that we approach these, because before it was, well, the protocol for the county attorney's office, for the city prosecutor, is that we want to get these interviews recorded. And so they kind of wait until it's time for making the formal interview, and then they record everything once everything's calmed down and the situation has been settled. But what we want to try and capture now is the original chaos of the scene when the officers arrive. So we want to know what all the excited utterances are. We want to have those recorded. We want to have the dynamics of the approach and hearing the furniture being thrown around and glass breaking, and all those types of things are going to become important when the county attorney has their briefs.
Right. Because of logistics, I kind of have to pop over here to insert a comment. One issue on the body cameras that we're seeing quite a bit of is we like to not have to redact really anything from those body cameras. So what we're asking is, a lot of times, you get an ID from a victim, and sometimes the officer just kind of holds up the picture to the body camera, and now we have sensitive victim information right on the middle of our investigation that we probably have to redact out, it becomes a little bit of an issue. So for those people using body cameras, we just kind of encourage you not necessarily to document it and record it that way. Get it the long way so that we can actually have a better way of having the whole recording, but not having something in the middle that we have to chop out and then people wonder what it was and things like that. So just want to insert that while we're talking about that.
Great. So when you're actually interviewing and talking to the victim and the suspect, we want to know what the nature of the dispute is. And it's not only just what they say, but it's noting all of the aspects of their demeanor. So we want to know if they're emotional, if they're crying, if they're upset, the victim versus the suspect. And sometimes you may not know, who the suspect and who the victim is at first, but just noting the demeanor of each party and getting their physical condition, if their clothing is ripped or torn, the physical condition of the scene, if chairs are turned over. We want to be able to paint a picture for the attorney and for the jury later on if it gets to that point, so we can clearly display, exactly paint the picture of what we were walking into if we're not wearing those body-worn cameras. We want to adopt a neutral approach. Obviously, some of the feedback we got from some of our victim sessions with the protocol model is that they felt that the victims felt like they weren't being equally spoken to as much as the suspect was. And it took a lot of information sharing between law enforcement group and the victim advocate group and the victim survivor group to talk about exactly why we take the approach we do in some cases where it may seem like we're partying to the suspect, but really we already know that they're the suspect, and we're trying to elicit information and try and get them feeling comfortable speaking with us in order to get more of that information to kind of lock them into that story and be able to use that later when we go to prosecute them. If we're refused entry into the house, officers should persist seeing and speaking alone with everybody that's subject to the call. If access is refused, the officer should force entry. And again, this is depending on if you've got the exigency, the emergency situation, that we can articulate that. Normally in a domestic violence call for service, when it's ongoing and it's present, it's fairly easy to articulate that. But we want to talk to everybody separately. We know about the problem with DV intimidation, and when you've got both parties in the same room, trying to get that information sometimes can be hard when there's mad dogging going on and when there's just those inherent tension that derives from the domestic violence relationship. We want to be able to assess the injuries, administer first aid if we need to, and then notify emergency medical services. So obviously, physical safety of the people involved is going to be paramount, so we want to ensure that we've got the physical safety taken care of. If it's something that can be seen by their primary care physician or something later, we just want to encourage the victim to seek that medical documentation or that medical treatment if possible. But then we also want to receive the documentation on that treatment, because obviously that becomes important later to document what the medical findings were for those injuries. And this also goes into not just the emergency room or the primary care, but if they have to go and they get their glasses broken, they have to go to the optometrist. A lot of times we can get good information from those types of doctors. So we've got the optometrist, we've got the dentist if there's dental work that needs to be done. And sometimes that kind of just falls out of the realm when we're not thinking about emergency rooms and hospitals. But all that information, those doctor's notes, can be useful later on in the prosecution side of things. Do not become overly involved in the disposition of personal property or ownership, or being neutral, and be concerned primarily with maintaining peace and safety of those that are there. So again, we're not there to be the judge to determine who gets what property and all that. That's a civil standby, and we're really not there at that time to do that. We're here to determine if there's a crime that's been committed, and we're ensuring the safety of all the people that are there. Ask the victim lethality and danger assessment questions, determine the level of danger that victim is facing in the relationship. Now, if your agency doesn't use a lethality or danger assessment, it doesn't mean you can't ask those types of questions. Part of what your handouts were today was the Glendale Police Department offense report. If you go to page 3 of that, that goes through all of our lethality and course of control assessment questions. And in those sections, those are just questions. So, I mean, it doesn't mean that you have to have a place to put those. If it's just you're asking those as part of your normal investigation technique, a lot of times you can just document those answers in the narrative of your report. So just finding out that information, you can glean a lot about the dangerousness of the situation, and then maybe get victim services involved to help that victim if you deem that they kind of fit that criteria. What we'll do later is go over what our exact criteria is when we use this tool. But if you don't happen to use the tool, you can obviously just get an idea by getting them to answer some of these questions. We want to offer on-scene assistance to victims. So the officer should advise the victim of their constitutional rights, explain the suspect's initial court appearance will likely occur in less than 24 hours. We want to get them access to translators if there's a language barrier, so obviously using like the language line, something like that, if you're having a language barrier, because obviously getting the victim's side of things is going to be very important. And if you've got a witness, maybe that can lend some information, and we all know how valuable witnesses are on especially cases where it's more he said, she said with the suspect and the victim. We can get a witness involved. We just don't have the language interpreter there at the scene using the language line or some other fashion of getting that statement can oftentimes be the difference between a case being turned down and a case being filed. The officer should assist the victim by putting them in touch with victim services, conduct safety planning, provide them all their victim's rights information, their compensation information. If they need emergency phones or lodging, shelter information, all that can be done through victim services. So if there's some need that you can tell that victim might need, then make sure you're putting them in touch with the right folks to do that while you're on scene. So what's some of the problems with the way we've traditionally handled DV? When I say we, I mean just law enforcement in general. Generally, we put together the case, which composed of usually the suspect statement, the victim statement, and some photos. Now, this is traditionally what we do because this is all we need to do to produce our probable cause to make an arrest, which in law enforcement, that's what we want to do. We want to find out if there's some crime that was committed, who committed it, and as long as we've got the probable cause, then we go ahead and make the arrest. Generally speaking, that's not always enough to hold somebody in custody or to actually take it all the way through to trial. So what we need to remember is probable cause may be enough to arrest, but it's not proof beyond a reasonable doubt, which is the threshold that the attorneys need to be able to put this case in front of a jury. So build a stronger evidence-based case. This is the solution that we want to do. We want to not just have the photos and the victim and suspect statements, but we also want to be looking for witnesses. If there's not a witness on scene per se, look at the neighbors. Look at canvas, just a short canvas. If we're in an apartment complex, we're talking neighbors upstairs, neighbors downstairs. If we're in a neighborhood, we're looking across the street to one side or the other. Because most of the time, you'll have that nosy neighbor that knows everything that's going on, especially when it's a domestic violence situation that's going on in their neighborhood. They're going to have some information. May not be on today's incident, but it may be on some relevant history. We're looking at physical evidence. We're looking at the medical documentation that we talked about. We're looking at, are there kids in the residence? And I know a lot of times, especially police officers, we're real hesitant about trying to talk to kids because we're not really confident with our interviewing skills, and we don't want to mess things up, and we'd rather do a forensic interview later. Well, a lot of times if children are witnesses to something, they may just come up and tell you. They may just be have those excited utterances as you're responding, which is another good reason to have your recorder on and your body-worn camera activated during the whole process. So you're capturing a lot of those excited utterances. But then again, just remember, if it's under 12, you're talking about just the who, what, where, when questions. We're not expounding. We're not going into anything additional. We're just kind of getting that basic information. Your teenagers and older kids, you're able to just interview like you would normally an adult witness. New evidence. This is something that we'll talk about in a little bit, but new evidence is stuff that will come up after the original call has been serviced. So we've made an arrest, or we've made a submittal, but now the victim's getting threatened, or now the victim's receiving flowers or something else that might be construed as intimidation or influence on them not to show up for court or not to continue with the prosecution. We want to be able to document all that, and we'll talk about forfeiture by wrongdoing and those types of hearings and why these things are important, especially when we want to bring in a lot of the hearsay evidence. Follow-up interviews and photography, we'll also talk about that in a little bit. So we'll have some examples of photos where you'll have a victim, and they might just have a small mark on their arm, but a couple days later, 72 hours later, you're going to have a nice big bruise. And that's going to look more appealing to a jury and to a prosecutor wanting to file a case than the original mark that was there at the scene. So making sure we're going up and following up with those victims and getting that medical follow-up, the photographs of the medical injuries can oftentimes be that piece that puts a case over the edge and over that threshold where it's no longer not a likelihood of conviction, but yeah, there's a good chance we could get a conviction because this has a lot of jury appeal. So that's what we're looking at. Criminal history, we want to look at not only our case agent or our case history with the two folks involved in the DV, but we also want to know what the criminal history is of each. So we want to know, is there prior DV criminal history? Is there prior violent acts that are involved in their criminal history? And again, that all goes to just being able to paint that picture and having a more solid case that's evidence-based for the prosecutors to use than purely relying on the victim testimony, which we all know in DV can be varied because DV intimidation is so rampant, and there's so many other factors that are involved in a DV victim's life that we can't hold against them, but we've got to make sure that we account for when we put our case together. So we're doing the best thing that we can do for them in their situation and not putting all the burden on the victim themselves. So our on-scene investigation, what we're looking at. We're conducting all the interviews by identifying, separating, and speaking with all the witnesses, including the children. We're utilizing our danger assessments when we're using them. And then not only that, but we're clearly articulating the results of that information to the victim. So if we're using a tool that tells us if they're in a dangerous relationship, if we have that information, it's now our responsibility to relay that information. So we have to let the victim know, hey, because of the way you answer these questions, now we know that you're most likely in a high lethality situation where there's a good chance you could be seriously injured or killed. And we want you to know that. We want you to be able to take the necessary safety steps. Here's some safety planning. Here's a victim advocate that we're going to put you in touch with that we can kind of go through some of these steps and make sure that we do what we can to best ensure your safety. Taking audio or video recorded statements of interviews. So not only are we doing the stuff on scene, but we can also, if we need to bring them in for a formal interview later, we can bring them in and bring them in the station and do a formal interview in an interview room. Using supportive interview techniques to ask about previous incidents, allow the parties to describe and explain without interruption. The days of the Joe Friday, just the facts, ma'am, are over. We don't want to be just cutting them off and just wanting to know what happened today type things when we talk to DV victims on scene. That might work for the burglary, or that might work for the any other types of crimes. But when we're talking about domestic violence, we want to know what the history is. We want to know what led up to this. We want them to be able to freely speak about their situation, because there's going to be a lot of stuff, a lot of information that we'll be able to glean about the dangerousness again. And when we want to prioritize or triage cases, that's where we're going to get that type of information. The other part is, when is the victim most likely wanting to speak to us? It's going to be right then. It's going to be while we're on scene. It's going to be while they're still upset, while they're hurt, and while they're willing to give us the most truthful and forthcoming information. So we want to get that information right then and there. If we wait and try and contact them 24 hours, 72 hours later, a week later, 2 weeks later, there's a good chance we're not even going to get a hold of them, rather than get all the information that we want for the case. And for those of you that are detectives or have been in this situation, you kind of know that oftentimes it's harder to find the victim after we get the initial report than it is the suspect. And so while we've got the victim there and willing to talk to us, that is the best time to gather that types of information. And then again, no telling the information what action will be taken until all the information is collected. So a lot of times you're still dealing with those love aspects, you're still dealing with the intimidation aspects, and they know from the last time he went to jail, when he said, if I ever have to go back to jail, there's going to be these consequences. So if you tell the victim prior to asking your interview questions, hey, don't worry about it, he's going to go to jail, you're going to skew and she's going to temper her responses to you, because she's not going to want to get those consequences back. So again, try and get all that information at the front end, and then let the victim know what's going to happen with the case after you've gathered all the information that you're looking for. We want detailed information. So we're looking at specifics about what led up to the violence. We're asking what they were arguing about specifically, what rooms they were in. Again, if we have to recreate this scene in front of a jury, it's good to know that they started in the bedroom and then worked their way into the kitchen, and that's where he got the knife, that's where she got the hand cut. And when we're taking our photographs of the scene, we're also following that same line of from questioning that it started in the bedroom. So we're taking pictures of that bedroom, the hallway, the kitchen, where the knife block is located in the kitchen on the counter. We want to be able to recreate that scene if we need to. So taking photographs that also tell the story are just as important. We want to know who else was there. If somebody has a warrant and they know the police have been called, are they hanging out until we get there to give their witness information? Probably not. So asking those questions is usually the only way we're actually going to find out if there was other people at the residence at the time of the event. And again, we can make those interviews at a later date or right then and there if we're willing, if we can convey to those witnesses that we're not there for whatever issues they have. We want to just get the information, reference the DV incident that was there. Another thing is repairmen, and like if they're having work done at the house and they've got construction workers there, the landscaper was there. A lot of times asking those types of questions will find us a witness that we didn't even know existed. Ask where they were hit, how many times, and with what. So we're talking about getting more descriptive on just, oh, it looks like you've got a bruise on your arm. How'd you get that bruise on your arm? What do you think caused it? And get a number of times that they think they were hit. And obviously, it's just their guesstimation, but it'll help when we try and relay this information to the prosecutor later. Ask if they had to defend themselves. A lot of times, officers get tripped up in the fact that both parties might have injuries and wanting to know, well, do I arrest both of them? Or we have a self-defense law in Arizona for that specific purpose. The other person, the suspect, can have injuries, and that's okay because the victim has a right to defend themselves. And it comes down to our interview and interrogation skills to derive how exactly that all took place. So if the suspect has injuries, it's okay to ask the victim if they assaulted or if they had to defend themselves to cause those injuries. Because we want to be able to explain them. Because if we don't explain them, who is? The suspect's going to explain them, and he's going to explain it putting the onus back on the victim, saying that the victim started everything, and that's how they had to respond. So again, it comes down to how the interview takes place and accounting for all the injuries, not only for the victim, but for the suspect as well. Photographs of non-injuries are just as important. So taking photographs of your victim and your suspect, regardless if they have injuries or not, is always a good thing because you're seeing what they look like at the time of the incident. And then if they claim an injury later and it's not documented on that first set of photos, then they don't really have that leg to stand on. What do you think caused each injury site? Again, if there's fingernails and scratches, or if it's a weapon that was used, a curtain rod, anything, a broomstick, anything else, again, that'll lead us to more physical evidence that we can capture for the prosecution end of things. Then we want to compare the victim and suspect statements and then recontact when discrepancies are found. So oftentimes officers will show up and it'll be just they'll almost be like a secretary. They'll take the victim's statement, they'll take the suspect's statement, they'll take some photos, here's the case, and they really don't follow up and go back and recontact when those discrepancies are there. Obviously, we don't really have a whole lot of instances where both parties say the exact same thing about what happened. So you're going to have inherently those discrepancies. And so look at the physical evidence, where the injuries are located. Is it more consistent with one person's statement over the other? And then go back and recontact and hey, this doesn't fit. Let's try this again. What else can you tell me about what happened? Let's go back to this and start over. And again, just calling people on, some of the things that they say that may or may not be made up, or just to make them look better in a better light. Sometimes it takes recontacting them and pointing out those discrepancies and catching them in their lies to get them to really come forward with the true statement. Witnesses are valuable. Again, a lot of DV happens behind closed doors, so the only witnesses sometimes are children or no witnesses at all that we know of. And so canvassing for those witnesses and trying to find those witnesses is really what can make or break a domestic violence case in a lot of instances. So we're not only looking at who called 911, because it won't always be the victim. It may be a neighbor, it may be a concerned person at the school, it could be somebody else. So find out what information is being relayed to them or what they've actually observed, and then be able to use them. A lot of times when we get a 911 call, if it's something that's disturbing the peace of a neighborhood, you might have more than one caller. So you might have, or if it's happening on a street corner, you might have more than one caller. And so it's not just the person that the dispatcher decided to throw on there, but look and see how many other people called, because they may have seen something different than the person that we're actually talking to. So we might have multiple witnesses just based on the number of callers that came in through dispatch. So recontacting each of them and getting a good statement, because not only may that have more information or more detailed information to give us, but then when it comes down to the jury side of things and actually putting on a trial, we may have witnesses that are more credible or more available than others, some, just depending on the nature of everything. So the more people we get that saw what happened or can lend details to what happened, the better. Again, who was present? So if there was somebody there that just left prior to police arrival, we want to know that. Who did the victim text with? In this day and age, a lot of times before the 911 call gets made by the victim will text their sister or their friend, or somebody else about what happened and seeking advice or what to do, or just say, hey, this just happened, and that person can now be, used as a witness if we need to. But we can also gather the information that's relayed in the text, especially if that becomes an issue later where the story gets changed or recanted. Who did the victim speak with immediately afterwards? And this is before we got there. Again, along the same lines as the text messages, if they make a phone call to the sister, to the friend, and they relay information about what happened, that person can be useful to us in our investigation, getting a statement from them about what was relayed to them by the victim if we have to go through a hearsay hearing. And then again, just lock everybody into a statement. So once we got the information, we want to actually reach out and talk to them and get that statement and get them locked into that statement so it doesn't manipulate or change with pressure from the victim or from the suspect. Our on-scene evidence collection. We want to collect and preserve all the physical evidence. So if you've got a curtain rod that was used to assault the victim with, we want to collect, not only photograph in place, but then collect it. Take photos of visible injuries as well as the crime scene. If they said they were hit on the arm, again, take a picture of the arm. Even if there's no mark there, this is where it was. And then again, when you have your follow-up photography in 24, 48, 72 hours, you can see that injury progression as the bruise develops. And again, that's just more ammunition for the prosecutor and put in front of a jury. Collect the electronic evidence, including all social media. So if it's not text messaging that happened, but it's a Twitter post or something on social media, then again, we want to collect that as well. Request and review a copy of telephone recordings, the 911 call. If the victim's the one calling, we can get a lot of good information out of that 911 call, and maybe stuff that got shorthanded by the dispatcher just to get the information out, but there's really some valuable information in there. Background, you can hear the suspect yelling at her in the background, and those types of things, which you wouldn't have known if you hadn't requested and then reviewed the actual 911 tape. So especially a lot of times if you go out on a call and it's dispatched one way, but then everybody seems a little scripted when you get there, and none of that's being relayed from the 911 call matches what's being told to you at the scene. You may want to just call over to dispatch and have them play it for you over the phone, just so you can hear what that 911 call sounds like and what information is actually coming through from the victim, because then you can directly rebut anything that's being said there at the scene. And again, that goes back to separating witnesses and getting them alone one by one to get a good, truthful statement about what happened, so you're not getting that intimidation or that scripting of what the suspect wants everybody to say. And again, we want to follow up with the injury progression as we can. Our medical evidence, a lot of times victims feel more comfortable talking to the handsome firefighter than they do the police officer that's there. So a lot of times you'll get a lot of good disclosures to medical EMS that you never got during your direct interview. So looking at stuff like this, you can see it's quoted up here, but I'll read it to you for those that can't see the small print. The subjective complaint, multiple injuries to the head, neck, torso, and limbs. Second to assault, lasting 2 hours from 1400 to 1600 per patient. Patient states she lost consciousness twice, unknown duration. Second to being choked with the suspect's hands around her neck. Comments, also was dragged by her hair with fists to the face, back, and chest. Patient states that she was tied up at the wrists and the ankles. Patient drove to the address where EMS was called. Are those good disclosures, good medical statements to have for your report? They're excellent. They describe how she got the injuries, what her injuries are, and the time frames that went into it. So a lot of times you'll get very good injury statements and mechanism of injury statements from your EMS and your hospital personnel from their disclosure, because again, in that medical setting, they'll feel more apt to give those truthful statements about how they got those injuries, where they may be more reluctant, just based on the consequences of DV, to relay everything to police. So again, with domestic violence caveats in HIPAA laws and those kind of things, we can still get all that information and use it. So we also want to be looking for our ER records, follow-up medical care with their primary care, interviews with the attending physician or the charge nurse. Might be able to give us some details about what happened or what they disclosed. Medical reports, including the doctor's notes, primary care physician, dentist, urgent care, optometrist, or any other medical professional that we can use. This is just a chart of what I explained earlier about the potential victim assistance with the case. And what we're looking at here is day one. You look all the way up at the top. That's when we get our most likely ability for them to disclose and give us truthful information. The further we out, closer to prelim, the more that drops off. And that's just because of the nature of domestic violence. And again, it's not something we hold against the victim, it's just the nature of DV itself. Intimidation sets in, love factors set in, a bunch of different things. There's kids, there's money, there's just life situations that's different for every victim, but there's multiple reasons why we get less and less help with the prosecution the closer it gets to the date. So we want to gather all this information right at the onset, right at the patrol response, to be able to get the most accurate information. We need to understand what the abuser tactics are. Whoops. Victim isolation is one of the most predominant tactics used by abusers to keep victims dependent on them. So they're going to do what they can to keep them away from prosecutors, from victim advocates, from police help, even from their friends and their family. Eventually what they're going to try and do is completely isolate them so they're solely dependent on the abuser for everything that they need, for their money, for their house, for their car, for their livelihood. And so if we understand that, we can start targeting our response so that we're actually able to intervene and open the victim's eyes to those types of actions by the abuser. And this is actually what's going on when they're making you late for work so that you get fired, or when they sabotage your schoolwork, or when they are teasing you in front of your friends and making a scene so that way your friends don't want to hang out with you anymore, and those types of things, so that they can kind of understand where the isolation aspect comes into it. Abusers belittle the judicial system when they're released. So again, when we put together a case and it's based on probable cause, but it's just not a slam dunk, and a lot of times there's just not enough information just to hold that suspect in custody, and they get out within that 24 hours. Then a lot of times they come back and say, see, they can't keep you safe. I'm right back out again. Here I am. And that also goes back to enforcing, conditions of release and going back and checking up on the victim when we do our follow-up and seeing if the suspect is back there and if there's a violation of those conditions. Abusers manipulate the court process. They take continuations. They assert their right to confrontation. And again, so if they want to make the victim get up on the stand and confront their accuser, that's one of their constitutional rights. And that can play a big role in the victim recantation, because they don't want to go through a trial or go through having the victim or the suspect confront them. So another part of the intimidation problem, they just don't show up for court, and so a lot of times they'll get dismissed. So if we have more of that evidence-based case to put in front of a prosecutor, they feel more comfortable being able to put on a case without the victim if they feel like they've got enough there. In all domestic violence cases, there are aspects of power and control. The abuser holds over the victim. Again, we know that may be a reason why they recant or they don't show up for court. And intimidation comes in multiple forms. Witnesses to domestic violence also face the same type of intimidation. So we got to make sure that we're touching base with the neighbors or the witnesses that we have in our case, and making sure the suspect hasn't reached out to them or slashed their tires or done something else that's going to keep them from wanting to show up for court. And that all comes into that new evidence aspect of things. If we're dealing with witness tampering or trying to influence a witness, that's a whole new charge all by itself, and we associate it with our domestic violence case. So the types of intimidation, we're looking at verbal confrontations, threats, physical violence, property damage, economic, in the courtroom. There's also coercion through influence. So it's not just intimidation, but it's promises of change. I'm sorry, sweetheart, that's not going to happen again. I can be better. So we're looking at love notes, letters, proposals, gifts, all those types of things. They may want to try and just use the sweet talk instead of the intimidation. We had a case where we responded to a local hospital, and it was on a stabbing, and the victim had been stabbed by the suspect. But in defense of herself, she stabbed the suspect back. And so they both had stab wounds that needed to be emergency treated in the ER. By the time our detective had responded to the hospital, they had already requested clergy from the hospital come into the ER and marry them. And you can imagine the tough time the detective had to try and get any information out of that victim when there was this coercion through influence, this promise that I'll marry you if you don't say anything. And so again, sometimes that's all that's needed. But those are hurdles that we have as law enforcement, as prosecutors, that we've got to work with and try and overcome. And again, we do that through the evidence. So how do we address the DV intimidation aspects? We want to provide the victim with all the information that we can, give them resources. And again, this can also be through your victim advocates and your victim services division. The victim will receive evidence of, if the victim receives evidence of intimidation or coercion, they need to furnish that to police. If you look in that DV offense report again, there's a yellow sheet that's kind of a tearaway page. That gets provided to each victim on a scene of a domestic violence. And that first paragraph underneath the personal information talks about what to do now. And again, that's just reminding them to call us and give us more information when we have those attempts to influence them or those threats or those types of things, because we want to record that. We want to document it. So if we do need to go through with a forfeiture by wrongdoing hearing, we've got that information documented. The case law support for that comes out of Giles versus California, where they said that acts of domestic violence are often intended to dissuade the victim from resorting to outside help. They include conduct designed to prevent testimony to police officers or cooperation in criminal prosecution. Earlier abuse or threats of abuse intended to dissuade the victim from resorting to outside help would be highly relevant to this inquiry and would evidence of ongoing criminal proceedings at which the victim would have been expected to testify. So again, you've got the case law support to say that, hey, we want to know about all these past incidents of violence or the current acts where they're trying to intimidate or influence to keep them from coming to court. We want to document that. We want to charge that appropriately. So here's just some examples of charges that we can relate to DV intimidation. You've got your threatening, intimidating, your assault, ag assault, trespassing, criminal damage, the influencing and tampering with a witness. Those are each its own charge. You can separate those out. Interfering with judicial proceedings, especially if they're violating the conditions of release or an order of protection. Use of electronic communication to intimidate, so kind of getting with the technology aspect of things. And then, of course, harassment and ag harassment. Stalking as well. Late reporting. A lot of times you'll get a late report. So it's not something that is in progress that's currently happening, but it'll be something that happened at a prior date. So we want to, again, look for those witnesses. So are we looking for people? Who else did you tell about the assault? Was there any evidence? Does the victim take any phones? Maybe she's got a selfie of herself in the mirror with the bruise on her face or the stitches that she got after she went to her primary care physician. And again, if there's a medical way of tracking it, so she went to her primary care physician, we want to go and get that record and bring it in. And even though it was a date that happened sometime in the past, as long as it's within the statute of limitations, we want to go ahead and put that case together. Past incidents. Has he ever hurt you before? And again, looking for those photos or that documentation that's going to corroborate things. Other police reports. A lot of times victims might be transplants here from another city. And so again, looking at those police reports from the place they came from. Confrontation calls. This is something that traditionally is used more in sex assaults and child crimes, but the transition has come through and it's made its way into domestic violence. And confrontation calls or one-party consent calls can be the difference in a he said, she said case when you can get the suspect to admit to something over the phone. And so again, you're having the victim come into the station or come into your advocacy center, wherever your detectives are, to put on this confrontation call and have call the suspect. Again, you're going to kind of script what questions you want this victim to ask or what topics you want them to bring up. And really the only thing we don't want to have is promises or threats related to the suspect in order to get them to say what we want them to say. But that whole conversation is being recorded, and then we can use that later on to prosecute them with. Our follow-up investigation, again, we want to go up and follow up with any types of injury progression photographs, or any other type of medical documentation we need to collect from the victim, any new evidence that we need to follow up on, etc. One of the main reasons that we want to take these cases and do as good a job as we do with, even on the misdemeanor cases, is we want to build up to this aggravated domestic violence charge. So whenever, in Arizona, whenever we have a third conviction within 7 years, that's a Class 5 felony with 4 months in jail. And when you talk about a suspect that belittles the judicial system because they get out of jail the next day, if we can hang an aggravated assault or an aggravated domestic violence case on them, that automatic 4 months in jail then becomes a big factor. That's a huge window for the victim to be able to leave and be able to restart their life and be able to get things going again. So again, 4 months is a whole lot different than that initial hold that we'll get on the first offense. So making sure that we're looking at those cases in that way, and pulling up their record, their history, will be able to get us those aggravated domestic violence charges. Again, looking at ag harassment, ag assault, stalking, dangerous crimes against children, child or vulnerable adult abuse, those are also felonies that we can use. Strangulation, that's also one. The key thing here with strangulation is that we're looking at the impeding of the breathing or the restriction of the blood flow. So a lot of times people don't think of smothering as something that can fall into strangulation, and it is because of the impeding of the normal breathing of the victim. So I'm gonna stop it there. I'm gonna let Hillary start with her prosecution side of things. Yeah, I'll flip you up there. See if we have another way.
There we go.
Oop, too far.
There we go. All right. This is forward here?
Yeah.
Okay. All right, I'll go ahead and do my part, and then Patrick and I'll kind of tag team and then get some time for questions here. Just a little overview of my background. I've been a prosecutor at the county attorney's office for almost 16 years. I prosecuted also in the city of Tucson for several years before that. Although I know you read my biography and you said, you know what, she scrapbooks and sews. I've got to come hear her speak. So thank you for indulging me in that. But last August, I took over as the bureau chief of the Family Violence Bureau. It's a bureau that I have done a little bit of a stint in back in 2003, 2004. I was there for a little while doing family violence cases. And I have to tell you, it's my favorite assignment ever, being the bureau chief of that group. I have about 16 attorneys that work for me. They have absolutely the thickest skins and the biggest hearts of anybody that I've ever worked with in my office. And you kind of have to have that when you work in this type of field with the victims and the type of cases that we do. So I can't begin to tell you how grateful I am for the people I work with and for the law enforcement community that supports our cases. It's so important to us. Like I said, these are the most likely cases that will end in a homicide someday, and anything we can do to stop it before it gets there, we're going to do. It's a very serious issue for us, and we really do take it to heart. I wanted to talk a little bit about some of the prosecution side. This is where you cue the law and order music in the last 20 minutes of the show, but this is basically what we have to go through here. Our job doesn't just come when the paperwork gets dropped off at the office. The county attorney's office has a prosecutor on call for various different bureaus in our office, 24/7, 365. So I have been on, Christmas morning at 2 o'clock in the morning, New Year's Eve at 3:30 in the morning. I've been at a scene somewhere doing something. It's not unusual. It's our job, and we will happily do it. If there is a domestic violence-related homicide, for example, or a very serious case involving a child where a child may die because of a child abuse case, we want to get on scene. We want detectives to call us and say, I've got this scene, I want to keep you involved, I want to keep you in the loop. Make sure if it's a domestic violence related incident or a child that when you call into dispatch to get the on-call county attorney that I need the family violence person. My folks are specially trained in a number of areas that the trial group on-call person or even the homicide person may not have the specialization that my folks have. So get the county attorney for family violence out there. We'll respond to the scene if you want us there. We're there, mostly to observe or just answer any general questions you may have. We're not the same as like the legal counsel for the police department, but we certainly do want to get out there. We like to attend the briefings that the officers have. We want to know what you know at this point, because sometimes we have to charge cases in a very short period of time, and having us there at the ground zero when the investigation is just starting can be so much more helpful than trying to read 500 pieces of paper that get brought in 3 hours before there has to be a decision on a case. So getting us in right away is incredibly important and very helpful. We want to walk through the scene once your techs and everyone has gone through it and it's safe to do so. We want to see what you're seeing. If there's interviews of suspects and important people, we like to be present for those as well. We're not participating, but we like to hear what somebody has to say, because then when it comes time to evaluate the case for charging, I don't have to watch the video and take that time. I don't have to rely on a summary. I was there and I saw it for myself. I know exactly what the person said. At some point after there's an investigation, we get a submittal. And basically, when an officer believes that there's probable cause, they want to make an arrest, there's a packet of materials that's then presented to my office for review. And a deputy county attorney is going to review that case that's submitted to determine, do we have everything we need to go forward on this case? Are we ready to file these charges now? A lot of times there's, we read a case and we're like, you know what, it's a great misdemeanor, it's not a felony, I just can't get a felony out of this case in good faith. So what we try to do in those cases, if it's submitted on a felony, is my attorneys are basically trained, if they're not going to file a felony charge on a case that's brought in, the person's in jail especially, we'll call the case agent. We want you to know as soon as possible if we're going to make a decision that's not going to result in the filing of the felony charge that you thought might have happened. A lot of times this is a victim safety issue that we take to heart. You have somebody who's in custody. They are at this point not an imminent threat to that victim. So if for some reason the city prosecutor wants to keep the case going, wants to pick it up and file on that person and try to keep him in custody before he gets let out, or she, not going to go one way or the other, that might be an option that we want to explore, because that'll keep the person in, keeps the victim safer. Because what happens is, in some cases, we don't file the felony if nobody knows that until the paperwork comes back and the officer sees it later. That person may have already been released from custody, gone back to the residence, injured or done something to the victim again, maybe escalated things, and then there's an officer safety issue, because now an officer who's now saying, oh, they're going to go arrest him because the prosecutor at the city wants to file a charge. Now we have to send out officers again to go to a residence where there's been a domestic violence offense, put themselves in danger, and make another arrest. So it never gets better for the victim. So we try to act on these things as quickly as we can. Doesn't always work out, but it's certainly something that we conscientiously try to do just to keep the victims as safe as possible and to see if the city's going to pick up those charges. And it goes both ways. I get calls from city prosecutors who say, I got this, I really think it's in your wheelhouse, can you take a look at it? And we try to act on those very quickly as well. We're looking for certain things when we get the submittals in, and this is, fairly important, because we've gotten some pretty serious cases, and sometimes we have a one-page little summary of what happened. And it's just heartbreaking, because I know that at the other end of that paper somewhere there's a victim who needs us, or needs some kind of assistance, and we just don't have the documentation to file what we need to keep that person in custody. So we're looking for, as much as you have, all the police reports and the supplements that are there, any photographs of the scene. A lot of times we don't have photos of the scenes. I don't know why. Pictures of the victim, the suspect. In strangulation cases, medical reports, forensic nurse examinations, those are very key. The nurses I know have them, but sometimes there's a slight delay in getting those to us. We really want to see those, especially in our strangulation cases. Those are the ones where we have to make a lot of calls and a lot of judgments on whether we have an actual strangulation or enough information to prove to a jury that we have a strangulation. Sometimes he put his hands around my neck is not going to quite get us there. There's other things that we're looking for. So having that forensic nurse report, their photographs and their assessments are incredibly valuable. If you have 911 calls at that point, we'd like to hear them. I know they're not always instantaneously appearing, but sometimes that might be an issue. If we can get those, that's always good to have. Are there recorded interviews with the necessary parties? We don't necessarily need the recordings right there and then, but document if there is a recording, it's available. And if we need to get it right away and listen to it, at least we know that it's there. Forensic interviews of child witnesses. This is a big one. And I know Patrick talked about this a little bit, but if there are children on scene who are able to communicate with the police officer, please make sure that if they've seen something and you have the quick little who, what, why, where, and when, that you get that child separated before they get back into somebody else's presence and change their story or start talking to their other brother or sister about what happened. We need to treat them like every other witness. They probably need at some point to be forensically interviewed if they're young enough, or if they have some kind of disability where you think a forensic interview is going to be helpful. All agencies should have a copy of the on-call forensic interviewer list. If you don't, let me know and I'll make sure you get to the right people who can provide that. But it's absolutely essential that children are interviewed appropriately and we get their statements preserved, because you get those people back in the presence of, for example, a recanting victim, that child is not going to repeat that statement. You're going to lose a very valuable witness. So getting forensic interviews is absolutely critical. Any other miscellaneous records we might need? Do we have, the prior felony convictions if you want to file a aggravated domestic violence offense? Do we have what we need there? The other thing that we like to have, and I know this isn't something that would necessarily go on the formal report, but we really like to have good phone numbers for the detectives that are submitting our cases. I can't tell you how many phone messages and how much phone tag I've had to play, with some people. And just having a way to communicate with that detective to say, hey, I saw here in the supplement there's a witness that lives next door. Did somebody talk to that witness? Can you get me information on that? Having a quick way to access the detective is so essential and so important. Even if it's a matter of the agency sending over to my office, here's a list of everyone's cell phones so that if you have a question right away, please call us. We do that constantly. So please make sure that if you submit something and you're going to be off for the next 3 days, make sure somebody knows if you have a question about filing this case and you need to get a hold of me, please call this number, because we would rather call and have some legwork on the front end than wind up furthering a case, having somebody get out of custody who might be a danger to a victim and having to go through that whole process again. We like to get our cases handled very quickly. As far as in-jail time limits, when a case happens, then if there's an arrest, that person usually has an initial appearance. They have to have that within the 24 hours. If they're held in jail after that initial appearance, we then have 48 hours to file our case. So the clock starts ticking very quickly upon making an arrest. Otherwise, there might be a police investigation where you don't make an arrest right there and then because you need to gather some materials. It's not quite ripe. You don't know if you'll get us the information in time. And then it's submitted to us as a basket case, and that's within a reasonable period of time. Timelines, actually, I'm going to go through this kind of quickly. They vary based on whether we have an in-jail case or a basket. And I have, a little example here about the holidays and when you exclude those particular days. But make sure that when you have a case where you think it might be an aggravated assault, like, oh, they must have a broken arm or the broken nose, which is always a source of an issue. Make sure that you're getting us medical records and things very quickly, because if you think, oh, this is an aggravated assault, and so I'm going to take my time, I'm going to get these records, and I'll submit it later on, we'll get the case, we'll be like, oh, we don't have everything we need, so we have to give it back to you. And by the time you get the medical records and the exact document we need, the x-ray, it actually wasn't a fracture. This could only be a misdemeanor, and now we've blown the time limits on it. So that occasionally happens, so make sure you're pretty expeditious with getting us the records and things that we need in those cases, especially if you have a fracture that may not be absolutely obvious when you're looking at it, like a bone sticking out or something like that. Basket cases, they don't have the same 48-hour time limit, but we do like to get to those within roughly 30 days of them being given to our office and then me assigning them. So we give our attorneys 30 days to review them. That doesn't always happen. Some cases are incredibly complex. They can be investigated for quite a while. Sometimes it's just thousands and thousands of pages, and my attorneys are, busy in court and everything else. So it's not always a 30-day turnaround time, but we try very hard to make that happen. One thing I will tell you is if, for example, you're working on a big investigation and you're not going to arrest the guy today, but maybe it might be a few months down the road. You have to get these documents and this thing from out of state. If you have something big going, I don't mind if you call my office, and I'll talk to you about getting maybe an attorney assigned to it to kind of babysit it with you. And that way, when you decide to make the arrest, you're not walking into our office with a big old binder and saying, hi, I know you have to file this in 3 hours, here you go. That sends us into some kind of heart attack mode. We don't really like to do that. We have to be really fair when we're evaluating the cases to everyone, including the suspect. We want to give everything the best review that we can, and having a huge binder of things and only a short period of time in which to do it is not the most efficient thing. So we really would like you to start a rapport with us if something is going on. If you know you're going to submit something, I'll get it assigned to a prosecutor. You can kind of send them materials as they go. And that way, when you are ready to make the arrest, we're ready to do the paperwork. And it's just kind of a team effort. We like working that way. We like to, have everything go smoothly. So please try when you're going to be submitting those big cases to sort of give us a heads up as much as you can, just because it makes everything work better. The other thing that we have to do is if we get a report, we have certain time limits in which we have to redact the information, and our boss has us attorneys personally doing that. Sometimes those medical records and CPS records, I have attorneys spending 7 to 8 hours, sometimes if the system crashes longer, having to redact those documents. So the sooner we can get things in and into our system, the better off. So please keep that in mind. As far as the actual charging considerations, we want to determine is there a reasonable likelihood of conviction. We have a very high charging standard. We don't like to to go to trial on the iffy cases. We really like to have solid evidence to go forward on a case. So we're looking for whether the police report has all the information that we want. Do we have everything to support all the elements of the crime? Are the witnesses credible? Are they consistent? Are they available? Are we going to be able to put on a trial with the information that we have? And these are some of the considerations that we have. There are very many. One thing that we can do, let's say you submit a case and some of these charges are okay, but we need some follow-up on some others. What we might do is something called a holding complaint. And that means that we know we can file, an assault charge on them. We got on the aggravated assault, but as far as, a strangulation from something that happened earlier, there's information we're missing. Or maybe there was, some drugs found on them. They need to be tested before we can file on them. We just can't do that right now. What we might do is just file a holding complaint, which means right now I know I want to file this charge. By the time the case goes to grand jury, which is going to be a few days down the road, I can add on the other charges at that point. But at least for now, I'm going to hold this person in custody on this charge because I know it's there and I know it's good. Turn down. So sometimes the detectives get back a form and they're like, turn down for what? Cue the music. A lot of reasons why our office will turn down a case. Some of it deals with victim credibility issues, and it's hard to say, this person's been through some traumatic event, but sometimes it just doesn't make sense what they've had to say. There may be significant impairment from intoxication or things like that. It might be the case itself just doesn't meet the elements of the statutes. Our statutes are pretty specific and looking for certain things. Or just looking at the case as a whole, it just doesn't meet our standard of having a reasonable likelihood of conviction. So if you get a case back, it was turned down by my office. I know sometimes it happens, but if it's a case that you're very passionate about, if it's something that you don't understand why it happened, please, you can feel free to call and talk to the charging attorney and just say, hey, what happened here? Was there something missing? Is there something more I could have done? We will give it a second look. We'll never say, you know what, I'm done. If you don't make a lot of progress or have something, you can always call me, but I always like to have you talk to the charging attorney because they spend a lot more time with your case. We never mind taking a second look at a case that you're very passionate about, and sometimes we've changed our minds, sometimes we haven't. But every case is different, every victim's different, and we want to do the right thing. So if there's something more that you want to talk about, please don't hesitate to call us and chat about things. And again, this is also where those good contact numbers for you come in handy, because if we can't get a hold of you and we need something and there's nothing else that we can do and no one else can help us, it's either going to be turned down or furthered. So getting a hold of us is essential. Patrick was talking a little bit before we ended about establishing domestic violence priors, trying to get a person convicted of something domestic violence related so that eventually down the road they keep doing things, then you have a hammer there. If we get domestic violence priors within 84 months to 7 years, we get 2 or more of those, there's a very good chance we will file the aggravated domestic violence charge. Doesn't happen every time, and sometimes the underlying offense on that third one really should probably be handled in city court, or it's not meeting the facts of it themselves are not very good. So we won't file it every time, but we're trying to file these a little bit more as a felony, because it's very important, the pattern of domestic violence, especially if you have the same victim, escalating behavior. These are really key things that we're looking for. We want to get these people into felony court, get them on the felony probation, or send them to prison if that's most appropriate. As far as the charging of these cases, we need to see the priors. And I'm not saying I expect you to be at the clerk's office at 8 o'clock in the morning to get the certifieds for us. We don't need that. But we do need to eyeball. We need to put our eyes on the paperwork that you have to be comfortable to say, yes, this is this person's prior conviction. Because the last thing we want to do is file a case, get the paperwork, and then we just can't match it up to the person. I did a previous brown bag, I think back in November, it was like an hour and a half just on proving prior DV convictions. So I'll save that hour and a half for some other time. But there is a lot of documentation that goes into it. Fingerprints are excellent, not essential for everything, but there's a lot of good documentation that's out there. If we can get it and just eyeball it, we can make that call and say, yes, we're going to go ahead and file the aggravated domestic violence charge. As far as the process for prosecution, basically you have the arraignment, and then he gets his initial pretrial conference, which is set out about a month or so after the arraignment. The initial pretrial conference is basically the first big court hearing where the prosecutor, defense attorney, and defendant are all together in front of the same judge. They'll talk about setting dates for trials, for other status conferences, and what's going to happen in the case. A little ways down the road, typically we have what's called a comprehensive pretrial conference, and this is the type of conference where the judge wants to know, are we close to trial? How many days? How many witnesses? How many people still need to be interviewed? It's kind of a, for lack of a better term, a little bit of a babysitting conference by the court. The court wants to know how close are we to actually going to trial on this case. And then finally you have a final trial management conference where the parties just go in and inform the judge if this case is absolutely ready to go or if there is a continuance that's needed and why. And then finally we get to our trial phase. Trials in Superior Court are done by mostly by master calendar. There's some cases, for example, our death penalty cases are just assigned to a judge and that judge will keep it. Some cases, because of certain reasons, judges keep. But most of our cases go through the master calendar process. And that means the prosecutor and defense attorney and then the defendant in custody or out show up at I like to call it kind of a cattle call at 8 o'clock in the morning, and the judge will see who's there, who's ready, and send them off to an available courtroom. A lot of hiccups sometimes happen. We run out of judges sometimes. You know, victims that we subpoenaed to come to that particular hearing to confirm that they are going to cooperate and participate don't show. We don't have them. We have to dismiss. A lot of things can happen at that point when it comes to the trial. What I want to do now is go ahead and get Patrick back up here too. If you have any questions for us generally on domestic violence, we're perfectly happy to answer those at this point. Or if you want to talk about scrapbooking and sewing. But sure.
In regards to the assessment, is this something that the patrol officers do, or is it something that the detectives do?
Correct. That's something that patrol officers do. So that takes the place of our general offense report. So whenever they go out on a call and they determine that it's a domestic violence, they've got a domestic violence charge, they use that report to document it on. So it's not a supplement. It's not an extra card or anything. It is the offense report that they use to take a domestic violence call.
I'm with Phoenix. We have hard enough time getting them to answer 4 questions. We have 18. What kind of cooperation do you give from the patrol officers?
It was a very tenuous process at the beginning to get it through, but basically we went through, we got the approval of the union, we got the approval of the chiefs and the commanders and the staff level over patrol. So when we rolled it out, we had all the buy-in that we wanted to begin with, and then we also had to we had to get all the buy-in from because what we do with these, the questions are only asked on cases of intimate partner violence. So that was one thing that they were able to say, okay, great, I don't have to use this on the group home kids that fight or any of that stuff. It's not for siblings, it's not for roommates, it's only the intimate partner violence that those questions get used on. So if it's a domestic violence by statute, but it doesn't fit the intimate partners, then they can just bypass that page altogether. So that was a big thing that they were able to swallow that in that case. As far as the questions go, what we found was initially there was a lot of kind of blowback from it because of all the questions they had to ask. But when we showed that the amount of time that officers were taking on calls for service where they were using this, it only averaged about 9 more minutes per call for service. So they could see that it actually didn't take that much more time to answer these questions. And they were also seeing the results from it. So they were seeing actually that, because we put this in front of when they're in custody cases, they get a copy, the IA judges get a copy of that along with the Form 4. So they actually get to see it. And so they're seeing holds, they're seeing really high bonds being set because of the answers to those questions. And then when they actually have to go through the questions with the victim, they kind of become the teacher on domestic violence. And so the officers sort of get a little bit of, they get a lot out of it actually, because they start asking the victims these questions, they get the answers, so they're a little bit more invested in the victim, and they write a little bit better report because they've got this extra information about the history. But then the victim asks, well, why are you asking me this? And then they have to explain why they're asking it. And as long as you don't have the officer that's just disgruntled and just says, well, just because we have to, if they actually say the reasoning why, because we put out a training on this, we went out and did all roll call, so it wasn't necessarily by electronic training or anything. We actually went out to all the briefings and trained every officer, graves, days, and swing shift, and got all the information from them and put out why we were doing this and getting the necessity for danger assessment and lethality assessment and protecting the victims. And most officers are in this job for the right reasons, and they were able to kind of see why we did that. So we got a good information out of it.
Yeah, the other thing about the lethality assessments is we're working on a project right now where we're going to be using those lethality assessments to kind of determine if an officer from a certain agency, even my office is working on this, might be paying the victim a visit right after somebody is released from custody. Because a lot of times what happens is once somebody goes through, sees the judge, a lot of times they might get released. And where's the offender going to go? Right back to the victim. So we're coming up with a program that's in the works right now. We're hoping to get a little more launched, but here's what's coming, where based on the lethality assessments and the risk to the victim, an officer may go back to that residence a day or two later and knock on the door and just make sure that that victim is okay. And, oh, is that Joe there? And Joe has a release order that says you do not return to that residence, you do not contact that victim, and then Joe will be quickly leaving the residence again. What they found in Pima County, they have a program down there that's going incredibly well. The recantation rate among victims down there has plummeted, in part because victims feel a lot safer. They feel like somebody's watching out for them. Somebody's checking up on them to make sure they're safe, and they found it to be very effective. So my office is kind of spearheading with a few other agencies to sort of pilot and follow up on some cases and see how it goes with those victims. Because what I found in my cases is if I pay a lot of attention to my victims, I'm getting a lot more cooperation and a lot more results. I've got a case right now where I don't know exactly how I did it, but I had a victim that we found out of state in an abused women's shelter. I talked her onto an airplane, and she came here for trial. And then when the trial got continued, I have all of her numbers. I call her once a week. She says, Hillary, I'm coming back. I'll be there. I'm part of this team now. And I have no doubt that when trial comes up, she's going to come back. And it's because of the attention that we're paying to her that I know she's doing that. And I think just having that in the beginning and letting victims know we care about you, you're important to us, we don't want you to have to go through this, we're here if you need us, I think that goes a long way. And having these lethality assessments is always a good way for us to start targeting who do we need to be paying attention to. What they do in Pima County is they actually have the victim fill out that paperwork themselves. Can you write that answer down there for? And now we have a lethality assessment in the victim's own handwriting. Becomes like a statement, and they're finding that that's very effective as well because, the victim can't say, well, that's not exactly what I said, that's just what the officer wrote. It's now their statement to the officer about what their fear is and what their concerns are. So having a lethality assessment is very good. I know that Mesa has a very good one. I really like the one that Glendale uses, and I'm not just saying that because Patrick's here. So just having something like that has been very helpful. So just that's part of why we like to see them, even if it is a little more work. All right. If anyone else has a question, if you can just push the little button on the microphone too, it kind of cues the recorders and acoustics. I'm still getting used to how the rooms work, but all right. Any other questions?
I have one. I don't know if I turned this on.
All right. If okay.
Oh, okay. I have a question about the follow-up investigation, where you said it could take up to 72 hours. If they go to their initial appearance and that case has been dismissed or not filed by the county attorney's office by that 72 hours, do you still do that follow-up examination anyway?
We try and put just the best case together we can. If it's an in-custody case and it gets dismissed, then, yeah, we probably won't get the extra evidence if we've already got the dismissal. But if it's something that's going to be set for trial and it's going forward and it's extra information that we can get, then, yeah, we'll do the follow-up that we can. Especially, like I said, those photographs are, when she's looking at a case and she sees, the huge bruise versus just the little mark, that's going to be a big telltale sign whether or not it's going to move forward.
Right. And the other thing is, too, in some of our cases, strangulation cases, the officer may note, I saw a little bit of redness on, the victim's neck, which to us doesn't mean there's a strangulation. But, you go back a couple days later and take the follow-up photos, and the forensic nurses always encourage the follow-up photographs. You may have, hand marks. You may have a lot better evidence a couple days later. So just that kind of follow-up is really good. I noticed one part in the strangulation, there's the materials that Patrick put together, all the, some signs and symptoms of things, document the raspy voice. If the person, you may not have met this person before, but if they, appear to be fairly young and healthy, and they sound like they've been, smoking a, carton of cigarettes a day, something to note in there. Note to see, and this is kind of a big one for us, ask them to, did you urinate yourself or anything like that? Because actually that's a very big telltale sign that a strangulation has occurred, because the body at that point doesn't care about bladder control. It's just trying to breathe. And that's something that happens. It's something that people get embarrassed about. Victims don't want to talk about, I wet my pants or anything like that. But, getting that kind of statement from a victim and even collecting the clothing becomes actually very important to us later on in those types of cases where it might have just been he hit her, or grabbed around the neck but didn't impede breathing versus an actual strangulation case. So anything we can get to make it stronger, we want to get. Anyone else? Okay, well, thank you all so much for coming. Again, my information's up here as well. 506-5999 is the main line to the Maricopa County Attorney's Office Family Violence Bureau if you have any questions. And like I said before, we always have somebody on call from our bureau to answer questions, and that's even during the workday. Just call down to the office, ask who's on call. If that person's in court or unavailable, somebody will pick up the phone and be able to chat with you about whatever's on your mind for that. So please keep in touch with us. We want to make sure that we're prosecuting these cases as well as we can, and it starts with good communication. So.
Can we get a round of applause? I would just like to take a moment to ask everybody to please grab a hold of this sheet right here. It's a survey. If you could just fill that out really quickly, at least the front portion. If you can do both sides, that would be great. This is how we track our progress here on these trainings, and we do use these in our grant applications to continue our funding so that we can provide these free trainings to you. Also, in case you missed my announcement at the beginning of the meeting, we do have a stamp to validate